Ladies and gentlemen, I'd like to welcome you out to tonight's Board of Adjustment meeting, December 20th, 2017. Call the meeting to order. I have an opening statement for you here. The Board of Adjustment is authorized by the Arizona Revised Statutes and the City of Tempe Zoning Ordinance. Its function is to grant relief where literal enforcement of the zoning ordinance would result in an unnecessary property hardship, to interpret provisions of the zoning ordinance, and to hear appeals from any person or city official aggrieved by the decision of a person responsible for the enforcement of the zoning ordinance. The board has the City of Tempe Community Development staff summary reports on the items being considered at this meeting, and will use this report in their deliberations. To introduce our board members tonight, at our left we have board member John Pazakis, board member Kevin Cullens. I am Vice Chair David Lyon. To my right is Board Member Jack Confer and Board Member James Frazee. We'll begin tonight's meeting by considering the meeting minutes from our previous session from last month. Do I hear a motion regarding said minutes?
Make a motion to accept the meeting minutes.
Okay, motion is put forth by Board Member James Frazee. Do I hear a second?
Second.
Seconded by John Pazakis. So I'll call for a vote, and I'd like to do votes by show of hands, if that's acceptable to everyone. All those in favor of the approval of meeting minutes as written, show by raising hand. And that passes 5-0. Okay. So having taken care of that, we have one case tonight, which is the QUACK Car Wash, PL 170240. This is a request to appeal the hearing officer's decision of October 3rd, 2017. If anyone is here that wishes to speak on the case as a member of our concerned public citizenry, we'll ask that you fill out a white slip of paper in the back of the room and bring it down to staff here. And when we get to that portion of the meeting, we'll give you your opportunity to speak. Which reminds me, I almost neglected to introduce our city staff. We have with us tonight Steve Abramson, Karen Stovall, and Diane McGuire. We'll thank them for their good work. So, having taken care of that, Ms. Stovall, if you will introduce our first case.
One minute, please. Good evening, Chair and board members. My name is Karen Stovall, Senior Planner with the Planning Division. This is an appeal of the hearing officer's decision made on October 3rd, 2017 to approve a variance to reduce the required landscape buffer from the street sidewalk for a maneuvering drive lane from 20 feet to 11 feet 8 inches in order to allow QUACK Car Wash, which is located at 5201 South McClintock Drive. The applicant is proposing a 3,349 square foot automatic car wash building at the southeast corner of McClintock and Baseline. The existing gas station would be demolished and replaced with the proposed car wash tunnel and self-serve vacuum canopies. Your staff report packet includes the hearing officer's staff reports, hearing minutes from October 3rd, the appellant's letter of appeal and correspondence received leading up to and following the October hearing. I'd also like to note that staff gave the board members copies of petitions and an email that were received following the completion of the staff report. And with that, if you have any questions of me, I'd be happy to answer them. Otherwise, I let the appellant make their presentation.
Thank you, Ms. Stovall. Okay, board members, questions for city staff? Please, Board Member Frazee.
A couple questions. Karen, I guess just from the very beginning, the understanding from the city to relocate the bus bay from where it is to 180 feet. When was that made, and what was the purpose of relocating the bus bay?
Chairperson and Board Member Frazee, that comment was made by Public Works, I believe, at the first time that we did a preliminary site plan review for the project. The reason was to assist bus passengers by moving the bus stop closer to the intersection. So if they were on a bus north or southbound on McClintock, they would not have to go as far to get on a bus eastbound on Baseline.
Thank you.
Other questions for staff?
Sorry, also a question in regards to that. So the preliminary site plan, is that when the owner of the property was first notified that there would be the additional dedication of the right-of-way and the bus bay?
So the preliminary site plan review submittal was made by the applicant, not necessarily the property owner. So our communication, staff's communication, was with the applicant, not the owner. I'm not aware of when the property owner was made aware of that.
Okay, thank you.
And Ms. Stovall, could you clarify then, when did you communicate the bus bay to the applicant?
The first preliminary site plan review comments occurred in February of this year, so February 2015.
Okay, so those
2017. February 2017.
Okay, so those comments were the first mention of it to the applicant. Okay, thank you.
Just a question. After the site plan was developed, there's a kind of a engineering type drawing in here, and there was a request for some variance on the 20-foot setback. Was there any discussion about could you still build the facility and keep a 20-foot setback? Is that something that they can do? Is there an engineering site solution to keeping that?
That's really a question that you'll need to ask the applicant, the developer for the site. Staff, evaluated the variance request. We are not going to see if an applicant can redesign the site to make something work. They came to us with their design criteria.
No, but this in the process of that discussion, when they came to you, was there any discussion about that?
The question did come up if the car wash tunnel could be reduced in length, and I believe it was reduced in length.
Okay.
I don't know the exact dimension, however.
Okay, any more questions? Yes.
Another question in regards to the right-of-way, and we can get into this more obviously with the applicant, but there's a comment that's made that the right-of-way request by the city and that the owner agreed to make the dedication in exchange for the variance. I mean, is that standard procedure, and is that accurate that the...
No. The city has no control over whether or not a variance is approved. So the right-of-way dedication was requested by Public Works of the applicant. The applicant determined that they could not meet that dedication without applying for the variance. But again, the city is not, does not approve or deny variances. That's up to the hearing officer.
Thank you.
Okay, I think we will thank Ms. Stovall and ask our appellant to approach.
Thank you, Chairman, Commissioners, Board members. For the record, my name is Court Rich from the Rose Law Group on behalf of the appellant. And before I get into my presentation, on my way here today, I was able to connect in the last hour with Mr. Abrahamson, and he indicated and reiterated the city's policy about if a member is absent, that a continuance is granted, and mentioned that staff would be apprising you of our request for that in light of that situation. You sit as judges here today in this case, and when you're before a court, if the judges can't all be there, they have either a judge sit in or they wait until all the judges can be there. The fact that there are less of you here today doesn't change the amount of votes we need to prevail in this case. And so in this instance, I guess I would ask, as I told staff I was going to, that in keeping with the city policy, that we be granted that continuance under the circumstances. I would also note we were handed a copy of the Board of Adjustment organizational rules from the city code, and it does indicate that when a member is unable to attend, that an alternate member shall serve at the board hearings. And so I want to make sure there's no deficiency here. I don't believe that an alternate member is here, or maybe perhaps has even been asked to be here. I think your bylaws require that. And I hope you don't hold this against me. And if we go forward with this, I'm happy to put on the case. But I'd like to have the full board of judges in front of me if I have that opportunity. So I appreciate your consideration.
Okay, well, that is certainly understandable. The math is clear. So now I have received, dear board members, some instruction from Steve Abramson, which tells us that we are capable of proceeding with a quorum of as little as 4. That would, of course, require that every member of the board voted in the affirmative for anything to be approved, because 4 votes in the affirmative are required for any motion to pass. However, our appellant has every right to ask for continuance, which, well, we now consider. We can have a discussion amongst ourselves if we think that that is an appropriate thing. If you'd like to make further case in favor of a continuance, you're certainly be happy to hear that.
Chairman, I would just reiterate, and this is something that I wasn't aware of until I read the code itself, after having been apprised of the situation. I mean, I think legally, and I don't know if a representative from the city attorney's office is here, but it says that the alternate shall serve at the board meeting if someone's absent. And so I'm not sure that you could hear this now, but again, that's something that you'd have to get advice from your city attorney on. And I'll leave it at that.
Okay, well spoken. I tell you what, being no lawyer myself, I will defer to city staff. Mr. Abramson, would you care to comment on that?
Thank you, Chairman, or Vice Chairman Lyon. We have a quorum, which we've determined, and I will read this is from City Code, or not City Code, Zoning and Development Code, Section 6, that describes the organization of the Board of Adjustment, and number 5 under this section indicates a quorum of 4 members of the Board of Adjustment is required. The concurring vote of the 4 members of the Board of Adjustment shall be necessary to act upon any matter on the agenda. You made that clear, Mr. Lyon. Except that on consent agenda items, which we have none of tonight, may be approved on, or continuances administratively granted as provided for this section. So we're not doing an administrative continuance. This is a continuance that you would hear. So yeah, in essence, you would be taking a vote on that if you wish to approve it. In the event that the board members are not sufficiently available to make a quorum, that's if we didn't have a quorum, 1 staff member is authorized to act as an alternate member for consent items only, and only to the extent that their presence makes a quorum. It says nothing in here that you cannot vote or have say in a continuance. So you do vote on that tonight. You have to have agreement to grant the continuance or not grant the continuance, not hear it, and just hear the case as presented.
Okay, thank you, Mr. Abramson. So let us now consider, shall we grant a continuance? Thoughts? Board Member Comfort, please.
Mr. Chairman and members of the board, I don't have any discussion. I'm prepared to make a motion if it suits the board.
Let's see if anyone has any comment first.
Well, I guess there's some clarification between what Mr. Rich said and what Mr. Abrams said. He's making a statement that we have to have somebody else sit here. Is there any clarification from that?
Chairman, can I briefly respond?
Please.
Thank you. Chairman, board member, and I guess just to read and quote from the code, since it's been quoted from already, section C1, the Board of Adjustment organization says, quote, whenever regular members are unable to attend or must decline due to conflict of interest, the alternate members shall serve at the board hearings, period, end quote. So it sounds like maybe there's a conflict within your own rules, admittedly. So yeah, I just wanted to be sure to read that to you.
I'm incorrect, Mr. Noggle, you are an alternate, correct?
He's asking
Oh,
if
I'm
you're an
sorry.
alternate.
I'm sorry, it's Mr. Confer that's the alternate. So we've filled there was one other person missing tonight, actually two. Let me get into that. Mr. Jansell, who is the chair of this board, whose term expires at the end of this month, could not make it here tonight due to conflict of interest that he declared. He declared that conflict of interest because he does business with your firm, Rose Law Group. That's his statement, and that's his determination to make on his own. The other individual that's not here tonight is regular board member Richard Cousel. Mr. Cousel is not in attendance tonight for his own personal issues. His term ends at the end of this month, and he chose not to be here tonight. So we have one alternate here tonight, that being Mr. Confer. And so we filled one of the voids. We did not fill both of the voids. And in that, I'm not an attorney. I can't dwell deeper into that.
Is that all then, Mr.?
One moment, please.
Okay.
At this juncture, we're clear to continue. I discussed it with the director of our department, and we can proceed.
Okay. So, board members, let me first say that Ms. McGuire has asked that we remember to push our microphone button so everyone in TV land can hear us. I believe that the matter is settled, that we are capable of continuing with our quorum. I also am amenable to a discussion of a continuance, because I think that's certainly understandable, given that 4 votes are needed and there are only 6 here. So I will hear a motion if there is no discussion. Please.
Well, I'd just like to say something. I mean, you could ask for a continuance even if the full board was here, could you not?
You could.
Chairman, Commissioners, yes, I could, and I'm doing it, one, because I was apprised of the City of Tempe's longstanding policy that they grant a continuance. That was what I was told earlier, generally in these situations, and certainly the math, as the Chairman acknowledged earlier, given the situation that you're sitting as judges.
So if the appellant is requesting a continuance for that reason, they could request a continuance even if we had a full board. In fact, they are. I mean, they want to have, they want to have a full board to hear this and to vote on it. I really don't see any problem with that. Although I would ask, is there a timing issue relative to what the city is trying to accomplish?
May I answer that?
Yes.
Okay.
I mean,
Couple of things. With all due respect, I did say that the city always had a long-term policy of granting continuances. I indicated to you that that you have the opportunity to ask for a continuance, but I didn't say there was a long-term policy of granting them. Aside from that, the fact that this case has already been continued at one point due to a lack of posting, and we wanted to make sure that we did this legally. It's already continued. The only issue here would be, again, a further delay in an actual decision.
Any further discussion, board members? I will chime in if no one else has an opinion on the matter. I have sat in plenty of meetings where continuances have been granted for a variety of reasons, not least of all being not having 7 members here. I can certainly understand the desire to have 7 members, given that 4 votes are needed to approve any motion. The math is not as good. And I personally am amenable to a continuance. Although it may mean some inconvenience to some parties, I think that it's perfectly within the appellant's rights to ask for it, and I'm inclined to grant it. Any other thoughts before we hear a motion? Well, I'll entertain a motion then. Boardman Confer.
Mr. Chairman, my motion was going to be in the opposite direction of.
Certainly fine.
Okay, I move to deny the verbal request for continuance for the reasons stated.
Do I hear a second?
I second that.
Okay. So the motion is put forward to deny the request for continuance by Board Member Confer and is seconded by Board Member David Noggle. Welcome, by the way. I will now entertain a vote. All those in favor of denying the request for continuance, please vote by the raise of hand. Sorry, I didn't actually mean to get ahead of myself there. I do not vote in favor of. So we have 1 in favor, all those opposed. And your vote? Okay, so let's make sure that I got this straight. I have Board Member Confer and Board Member Frazee in favor of denying the continuance, and you as well, Board Member Noggle. And then I believe that we have Board Member Pizakis, Board Member Collins, and myself opposed. Correct. All right, so the motion fails, and we have an interesting situation here because if we hear the reverse motion, we are likely to get the same result. What do we do then if we are deadlocked?
1 moment, please.
Mr. Chairman, I apologize for causing such commotion here. I appreciate your indulgence.
Well, you're well within your rights.
I think this is somewhat illustrative of the problem that hopefully doesn't befall if we go forward. But.
I'm sorry, all we're in new territory, so we're going to forge ahead here, and in that, you cannot make a decision as to whether or not to hear the case. It's suggested that the case go ahead and be heard.
Well, for lack
And
of
then you
other
can make a
remedies,
decision, but, at that point.
for lack of other remedies, I'm inclined to agree. Since we didn't have a motion that passes, we have to continue as we would have otherwise. So, if you are amenable, sir, please tell us your case.
Thank you very much, and I do have a presentation then that's loaded up if I can. And again, I really appreciate you listening to that and
Certainly.
look forward to presenting the case. this. I don't know if that's okay. Great, thank you so much. I appreciate that.
Chair, Court, if you don't mind. This may help you, Court.
Okay.
Court, I know. Mr. Chair, for the record, my name is Manjula Baz, law firm of Gamage and Burnham. We are the original applicant, and in the interest of, I know with court and kind of the indecision here, we also are happy to give court the continuance and wait for 7 people, if that helps the board at all. So I just wanted to say that.
Thank you, Ms. Vaz.
Thank you for your indulgence. Thanks, Court.
Please continue.
Okay, thank you. Mr. Chairman, again, board members, for the record, Court Rich from the Rose Law Group on behalf of the applicant. So in your role on the Board of Adjustment, you sit, as I've mentioned already, as judges in this case. And as you know from your experience, variances are not like a normal zoning case. They're not, do I like the use? Do I think it should go there? It really boils down to legal tests. And it's not, again, it's not a question of feeling. And I know as a land use attorney, I know variances are hard. I know that they are, and that's why they're very difficult, and they're very often not granted. And so we're here today asking that you reverse the zoning administrator who made a decision to grant this variance. And I want to take you through the legal tests and explain to you why I think this variance actually fails each and every one of them very clearly. And let me first introduce the 4 tests. Number 1, and these are right out of your code, summarized here. There have to be special circumstances that apply to the property. That means, and I'll get into it more, there has to be something unique about this piece of property that makes it unlike others around. And that has to be there for a variance to be granted. At the same time, it has to be shown that if you were to really strictly apply your zoning ordinance, that it would deprive this property of privileges enjoyed by other property owners. Now, each one of these, and I'll go through all of them, each one have to be met. So even if you find that this case meets 3 of the 4, just failing 1 means you cannot grant the variance and you must overturn the zoning administrator. Number 3, to grant the variance cannot be granting the landowner some special privileges. And number 4, the special circumstances cannot be self-imposed by the property owner. So let's get into this. Again, I've mentioned already, it's purely a legal issue. And I'm going to tell you why it's clear that no variance should be granted here. Special circumstances, case number 1, the first test. So the applicant on this case would argue that this giving of this 10-foot right-of-way was somehow special to them. Well, it's not. It's actually a code requirement. There's nothing special about the requirement that's been put upon them to dedicate these 10 feet of frontage. And here, in fact, I quote from your city code, from the engineering design criteria that sets it out. It says, quote, development of parcels located at the far side of arterial to arterial and arterial to collector intersections shall be required to dedicate a minimum easements of, and then it goes on to explain what they are, 4 bus bays per the city's exaction policy. So that is in the code. Every property that's at an intersection described in this code has to do this when they redevelop. Now, in fact, at the zoning administrator's hearing, the ZA actually asked your staff member, is it a normal condition that if you guys are looking for additional dedications, they come with site plan approval? And staff's response was yes, normal. This is normal. This isn't special, what's going on here. And here's an example of some other bus bays around town This isn't the only bus bay. It's not the only bus bay on a corner. There are many of them. And I've just got a subset of a few. Here's the southeast corner of Rural and Southern. Here is the southeast corner of Mill and Southern. Here's the northwest corner of, it's too far away for me to read, but maybe you can on the monitor in front of you. Sorry, Southern and, I can't, Priest. Thank you. I appreciate that. Contacts are a little fuzzy right now. Here's another one. I'll click through them. So bus bays are not unusual, is the point of that. They're not special. They're normal. They're required by your code. There's nothing unique or strange about the size or shape of this parcel. It's basically square, rectangular-ish. There's nothing going on there that's really interesting. In fact, nearby parcels are pretty much the same kind of parcels. You can just look within sort of this 1 mile stretch of road. Here's the site. If you measured back from the street, it's 200 feet in depth, and it's 33,000 and change square feet. If you go right across the street, you've got a parcel that's 150 feet deep and 22,000-ish square feet. And that one was on the corner. Here's a couple of mid-block sites, 150 feet deep, 24,000 square feet, 189 feet deep, 30,000 square feet. Going back to a corner lot down the street, 199 feet deep, 28,000 square feet. And across the street from that, 173 feet deep, 29,000 square feet. Again, there's nothing unique or special about this property in its size. So it's a legal test. That means there's case law, and that there's a case that actually just came out this year called Pawn First versus Jachemek, which is from the Arizona Supreme Court. And they said that in the legal test, you've got to show that the property's unique characteristics create exceptional practical difficulties. As I hope I've demonstrated here, there's nothing unique about this that creates a practical difficulty. In fact, it's not even unique or special to the block that it's on, let alone for the whole city. So I think it fails that first test, and it fails it very clearly. The second test is the no deprivation of privileges. And actually, before I move on, I forgot, I've got, if I could, I've got an exhibit, I've got another 20 or so of these different corner lots around the city that the lot depth and the square footage are on par or smaller than what we've got. I've got copies for each of you I can give you. Chairman, with your indulgence, I'd like to enter them into the record, and I can hand them out here.
Certainly, if you like, we also have means that they can be shown overhead, do we not? If you want to show everyone by means of the overhead, that's possible as well.
So it will take a lot of time, and I just thought I'd leave them with you if you'd like, but...
Within your rights if you
yeah.
wish to describe them, or we can move on and look
move
at
on
these.
and see if I won't take everyone's time. I already took enough time on the continuance issue, so I appreciate that. But if you have any questions about what you see there, I think it's 20 or so, just to reiterate the point, that there's nothing unique or special about the circumstances of this parcel. So I'll go on to test number 2. So this is the test where we have to show that by enforcing the zoning ordinance as is, that means not granting the variance, that the applicant has to show that somehow they're being deprived of privileges that others get. Well, that's just not the case here. So other designs would fit on this property. This lot is actually larger than many other car wash lots that we've found, and I've got examples up there of lots with other car washes on them, 26,000 square feet, 33,000 square feet, 20,000 square feet, 29,000 square feet. This lot's about 33,000 square feet. You can put a car wash on a lot like this. And you'll notice on the right side, we just today went on the Maricopa County Assessor's website, and you can click through and get plans for buildings often from that. And you can see that the length of the tunnel building for those car washes, that top right-hand corner, it's 100 feet. The bottom right-hand corner of this exhibit, that's 78 feet, the actual length of the building. What QUACK is proposing here is 108 feet. I think a board member earlier asked about whether or not they could build this differently, right? And I think the answer is clearly yes. Others have been able to build car washes that are not as long as this car wash. And so that certainly, it seems clearly possible. And in fact, we know it's possible because in Phoenix, they made an application, the same applicant, for a quick quack that they ultimately withdrew after the neighborhood was not happy about it. And that was to be on a smaller lot. You'll see on the right side of your screen there the plans from that was withdrawn. That was a 25,000 square foot lot, and it was approximately 96 feet. We were able to determine, it's kind of hard to read that plan, it was between 96 and 100 feet. Their current proposal is 108 feet, so in any event, it's less than what they're proposing here to the city. So not only that, but this site doesn't have to be a car wash, right? You don't have the case law is not, you have the right to build whatever you want on any piece of property that allows for the use that's there. If I want to build a house that's too big for my lot, I can't build the house that's too big for my lot. I don't come get a variance and say, well, I can't build the house I want because it's too big for my lot. No, the city says, well, you have to build a house that fits. And so that's the situation that we've got here. And there's been some suggestion that they believe that being located on the corner subjects them to two 20-foot landscape easements, and somehow that's a burden. Well, a corner lot is a benefit in the commercial retail industry, and so I believe that being on the corner is actually a benefit, not depriving you somehow of privileges that others get. So I think it's clear they failed that test as well. Number three, granting the variance clearly in this case would create a special privilege to this property owner that all those other property owners that I pointed out there in the packet I handed out and that we showed earlier are not entitled to. The code requires, as I referenced earlier, all property owners in this situation to provide this landscaping. That's in the code. To tell this property owner that they don't have to do it when there's nothing unusual going on here, there's no unusual size of their parcel, city hasn't done anything strange to these property owners, it would be improper and it would be granting them a special privilege. So you'd be granting a special privilege to an otherwise ordinary parcel. I would argue that they clearly fail this test as well. Now, number four, they have to show in order to get the variance that this was not self-imposed, that it's not their fault that they need the variance. Remember, this is just one of the tests. So if you think they've already failed one of the other three, it doesn't matter what you think about this one. But I think this one is very clear that this is their self-imposition and it's not something that was just thrown at them. So the applicant knowingly submitted a site plan that just doesn't work. They knew it didn't work because they went through, oh, let me stop actually. And this was something that was important to the zoning administrator when he reviewed the case. He said the dedication came at the time of application. It wasn't known and it prohibited application. It became known at that time. I believe that's reasonable enough of a hardship for me in this case. And he also said they are basically caught after their submittal or upon the time of submittal. It's my feeling, and therefore I don't feel it's self-imposed. Well, that's just wrong. That's a mistake that the zoning administrator made about facts, and I want to take you through the facts of this case. So, and again, those are, I'm highlighting, I'll respond to his assertion that they were caught or surprised by this. So the preliminary review comments on the first conceptual site plan were provided on February 16th. And it told them, and this is in the letter that we wrote on the appeal, has the attachments with these various documents. But the conceptual site plan had comments that said you're going to need to dedicate these 10 feet. Well, after all, it's in the code, so it should have those comments. They emailed about it with staff in March. They had another deficient preliminary site plan submitted in May. Again, this is all documented in the packet that we submitted. And then staff again told them that the design was deficient in June. And so what did the applicant do? They submitted anyway on July 24th and had the request for the variance and the proposal not in keeping with the city's zoning ordinance. That's really the definition of creating the problem themselves. So again, I've mentioned already that every design doesn't have to work on every site. There was a question earlier about when did the owner first find out about this? Well, an earlier application back in 2014 received a similar comment that they would have to, and this is in your packet as well, that they would have to provide this 10-foot this 10-foot dedication. So there's just no surprise here. No one was caught. This was a decision that the applicant made we are going to design this in this way, we know the rules, and then we're going to come and we're going to ask for a variance. It wasn't a surprise, oh gosh, you know, we submitted, we didn't realize it, now we're too far down the road. It's just not that situation. So, and this is a reference actually to that site in Phoenix that they were going to develop on, and this is pertinent not only to the earlier test that I mentioned, but to this test as well, in that, you know, if they could develop there on a smaller site, they should be able to develop here on a smaller site, and I think that was the site plan. So let me summarize here briefly, and then I'm happy to answer any questions that you've got. So we believe it must be rejected and that the zoning administrator must be overturned in this case. And I want to back up and say that, you know, I know this is a, so they might say, well, this is just a small variance. Well, there's nothing in the case law that says anything about a 1-foot variance having a different legal test, or a 10-foot variance, or a 100-foot variance, or a 50, whatever it is. It's all the same legal test, and that's your role here as the Board of Adjustment, is to apply the law to these facts. So there's no special circumstances in this case. This lot is just like any other lot. The code that's being applied to it is the same code that's applied to everybody else. They're not being deprived any privileges that any of those other folks with any of those other lots already have. And to give them this, in fact, would create a special privilege for them, where they would be the only parcel that would get to redevelop with a smaller landscape tract in an important corner piece. And it's clearly self-imposed. They knew about the issue. They chose to ignore the zoning code and come forward anyway. So with that, I thank you for your time. Again, I apologize for putting you through the continuance request earlier, and appreciate you listening to that. Let me know if you have any questions, and to the extent I have time, I'd like to reserve the ability to respond to what's said.
Certainly. Well, thank you, and no need to apologize, at least in my book. All right, board members, what questions do we have for our appellant? Yes, Board Member Frazee.
I guess, so the need for the bus bay on this specific site, it's your opinion, does not create the special circumstance.
Well, I think, Chairman, Commissioner, Board Member, I think what you have to look at, well, yes, that's correct. I don't believe it creates a special circumstance because your code sets out where these bus bays will be and requires them. It's just part of being in that location. The thing you have to consider is that if you believe this creates special circumstances, then every single applicant with a bus bay would have to, I presume, would be back here saying, well, you already said this creates special circumstances. And when it's every arterial, and every arterial collector intersection has to have these based on your code, I just don't see how you can find that that's special.
Thank you.
Okay, other questions for our appellant? Oh, please.
Just a real quick question. So if this variance was denied and the developer, the car wash developer came back, redesigned the site, then that would be okay?
Chairman, Board Member, the one issue is they need a use permit for this, and they don't even have that from the City Council yet at this point. So I don't think, or it's being appealed. That issue is not settled. But certainly, if they don't need a variance, then we wouldn't be complaining that the variance was wrong. So not to be flippant about that, but if they design it so it actually works on the site, that can relieve them of one of their issues, that's for sure.
All right. Seeing no other questions, well, thank you.
Thank you.
And I'd like to ask Ms. Stovall, do I understand correctly that you were the hearing officer on this case?
No.
I thought I heard that earlier, and I thought I needed to clarify that since we heard the zoning administrator is someone else.
No, the hearing officer is a contracted individual, not a city employee. I was the planner for the case, so I wrote the staff report for the variance application and presented it, the staff's presentation at the hearing officer hearing.
Okay, thank you. Thank you for clarifying. If I may, I'd actually like to ask if you would approach the podium again and answer a couple questions if we're amenable. Okay, Ms. Stovall.
Yes.
So there are 4 assertions which we've heard, and I know that I can't do as eloquent of a job of expressing those, but with regard to these 4 tests, our appellant has said the bus bay does not create a special circumstance because they are common, that this does not create a special privation because car washes can be built on smaller sites. This would convey a special privilege because they would be allowed to have a smaller landscape buffer, and this is self-imposed because they knew about this condition. Would you respond to those remarks? In your estimation, how does this case weigh against those measures?
So I would just like to point out that the intent of this appeal hearing is to consider whether or not the hearing officer made an error in his decision to approve the variance. I would like to make that statement. It sounds to me like you are requesting information about why staff made the recommendation of approval for the variance.
That's right.
Is that correct? Okay. I can go through the staff report that was written addressing each of the approval criteria. Is that?
If you can do that in an abbreviated fashion.
Okay. So we have in the staff report that due to the requested right-of-way dedication, the depth of the property is being reduced by 10 feet in order to accommodate the bus pullout. The dedication for the transit improvements that the city has requested of the applicant creates a special circumstance applicable to the property. The second one is whether the strict application of the code would deprive the property of privileges enjoyed by other properties in the same classification and in the same zoning district. The right-of-way dedication is being requested of this particular development along the north and south sides of Baseline. Elsewhere in the area, the half-street rights-of-way will remain at 55 feet. So this specific property in this specific area is having this hardship imposed upon it by the city's request for right-of-way dedication. The third criteria, the adjustment authorized shall not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and zone in which the property is located. There are a range of parking and maneuvering setbacks along Baseline Road, and granting of that variance would not create conditions that are inconsistent with other PCC1 zone properties in the vicinity. We surveyed, using aerial photos, surveyed commercial properties in the area, and other properties in the area do not have a landscape buffer from the back of sidewalk of 20 feet as required by our current code. The last criteria is that a variance may not be granted if the special circumstances applicable to the property are self-imposed by the property owner. This right-of-way dedication is being requested by the city of Tempe. It is not something that the property owner is coming in requesting for. So that's our evaluation.
Okay, thank you, Ms. Stovall. Any questions for staff? Seeing none, I will thank you, and we'll proceed to our public hearing portion. At the moment, I have one request to speak. If anyone else in our audience wishes to speak, Mr. Abramson.
I'm sorry, Vice Chair Lyon. At this point, the original applicant gets their opportunity before you open it to the general public.
All right, I thought that we would ask them to speak after the public comment so they could address those as well.
Typically, it's the applicant,
Fair
the
enough.
original applicant.
Fair enough. Well, I
Thank
stand
you.
corrected then.
Vice Chair Lyon. Lindsay Shuby with the law firm of Gamage and Burnham to North Central in Phoenix, Arizona. Thank you all very much for being here and hearing our case tonight. Again, as mentioned, we are the original applicant in the case. Court is here on behalf of the Rose Law Group, who is the appellant. This is it, yes. Thank you very much. Thank you, Steve. Okay. We represent QUACK Car Wash. They operate 50 automated car washes throughout Utah, Texas, California, and Colorado. And they are currently in the process of expanding to Arizona. specifically, and we've talked about this, not only Ms. Stovall touched on it, but Court did as well, talking about the southeast corner of McClintock and Baseline. Now, I was going to say, you see on the slide, it says existing conditions, but per the study session today, I guess that no longer exists on the site. But those were the existing conditions. You see, there's no big landscape buffer required. Another question was asked in the study session by a board member about whether there was a variance necessary on the property. This was developed almost over 25 years ago, I believe. It's been there for a very long time. There's always been automotive uses on this corner, but there was no requirement for the same landscape setback. Therefore, no variance was needed in order to properly enjoy this corner. Over the past 6 months, we have been working diligently and closely with staff to process our development application. Just last week, we did secure approval from the DRC, the Development Review Commission, for development plan review and two use permit applications. So as of right now, we are entitled to move forward. There may be an appeal from the Rose Law Group, but we are at our final stop unless there is an appeal by Rose Law Group, which we have not seen yet. Prior to these approvals, last week by the DRC, in October 3rd, we did secure approval from the hearing officer for this variance. It's a matter of discussion tonight. I think Ms. Stovall just did a really nice job of kind of explaining the city is requiring that QUACK dedicate the additional right-of-way along Baseline to accommodate the new city bus bay. Had it not been for this requirement, we wouldn't be here. It's that simple. We could develop on this site, on this corner, if we did not have that additional 10-foot of right-of-way dedication necessary for the bus bay. Now, the appellant has suggested through the written correspondence as well in the presentation tonight that we don't meet the approval criteria, and I disagree. They have compared our variance to a rezone request in a different jurisdiction, comparing the site size. That's completely irrelevant to the discussion tonight. There's been suggestion that our site is too small for our use, specifically citing that the other corners of this intersection have been developed without a variance. However, it's important to recognize that the other three corners at this intersection have a 55-foot right-of-way dedication. And there's no bus bay. QUACK is being requested an additional 10 feet of right-of-way, and therefore we are asking for an 8-foot reduction in our landscape setback. The appellant alleges that the variance, and this I don't know if this was said tonight, but I think it was said in front of the hearing officer, a convenient excuse not to comply with the city's very reasonable landscape setbacks. QUACK is actually providing 26% landscaping when only 15% is necessary. So we're 11% over in the landscaping requirement for this corner. And claiming that this is self-imposed because we are aware of the right-of-way dedication. It's an argument that we're still having a tough time to understand because in all jurisdictions, not only in Tempe, but when you process a site plan application, if something doesn't work and you realize you need a variance of some type, then you need to process the variance application. So it's hard to process a variance application without being aware that you need to have it. And again, the site would work. The site would work if not for this 10-foot dedication that the city is requesting of us. 4 criteria. The appellant ran through it, Ms. Stovall ran through it, and I will quickly run through because that's the crux of why you guys are here tonight. You're here to figure out whether we do meet this 4-part test. The appellant contends that there's nothing special about this property, the size, the shape, the topography. We agree. You know, those are a lot of reasons that are used for variances. A triangular shaped parcel, therefore you cannot meet the side yard setbacks, or you don't even know what the front, side, rear are. We don't contend that there's anything special about this property. The special circumstance and that's unique to us is that 10-foot right-of-way dedication. All other corners require 55 feet, and we're being asked for 65. This is special and unique, and it distinguishes us from the other properties at this intersection. Number two, the strict application of the code will deprive such property of privileges enjoyed by other properties. Again, as said by Ms. Stovall, in her original presentation, you saw the red on all four corners. All four corners are PCC1, but they all have the 55-foot right-of-way dedication. We're being asked for 65. It's as simple as that. In order to enjoy our property, we do need this variance, because without the request for the additional 10 feet, we could meet the 20-foot landscape requirement. That's the only reason why we're here. And again, I think it's important, and no one's really touched on this, the requirement is 20 feet landscape. We're offering 11.8. So we're close. We offer more than, we didn't take the whole 10 that they're taking. We're just about at 12. It's about an 8 plus reduction that we're, 8 foot plus reduction that we're asking for. Number three, the adjustment authorized shall not constitute a grant of special privileges. This variance does not constitute a grant of special privileges. The range of landscaping, parking, and there's a wide range of landscaping, parking, maneuvering all along baseline. The variance does not create a condition that's inconsistent with other properties with the same zoning on our property. And again, we touch on that 12 foot. So we're giving virtually a 12-foot landscape buffer when the city is taking 10. Also, if you look in your staff report that Ms. Stovall granted, it's important that the other corners didn't have the same landscaping requirement when they came in. If you look at the northeast corner, it was developed in the mid-70s, and the vehicle spaces currently have no setback along McClintock. So there's no question that the redevelopment of this corner, the addition of the landscaping, is certainly an improvement to the corner. Number four, a variance may not be granted if the special circumstances are self-imposed. Again, we could develop our site just the way it was with the code requirement of the 20-foot landscape buffer if the city didn't ask for the 10-foot bus bay. The court said the site plan doesn't work. At the time of the submittal, they told us they needed a dedication. We did continue to work with staff. We have the ultimate development of this car wash with the circulation and traffic patterns, things that aren't applicable to this case tonight. We're just talking about the variance, but things that were discussed at the DRC hearing last Tuesday. We have a lot of other things to contend with to make sure that we've got the proper parking, the proper turning radiuses, the proper queuing, and all of that to make this site work. In closing, I think we've demonstrated, and we agree with staff, that this variance does satisfy the approval criteria. This appeal, in my opinion, is simply another attempt to stop QUACK from operating at this intersection. QUACK has diligently worked with planning staff. We've agreed and happy to provide the additional right-of-way. I think what's also important is it's nice that the bus can pull off. That when those buses stop and it halts traffic, and I think there have been concerns about traffic and the development of the bike lane, being able to have this additional bus lane, I think, is a benefit to the city. However, because of that bus lane is a request for the variance tonight. City planning staff has reviewed this request, determined it satisfies all the criteria. The hearing officer, who is also a planning professional, agreed that we met the test, and I respectfully request that you deny the appellant's appeal and uphold the hearing officer's decision. With that, I stand for questions.
Okay, questions for the applicant? Yes?
I have a question. We are comparing what has occurred on the other corners of that intersection versus what is being required here. I am assuming that, but it's just an assumption, that the reason there's a difference is because city requirements have changed over these last 30 or 40 years. I am assuming that when these other places were developed, that they met city requirements. Is that something you can respond to, or should I ask the city?
Vice Chair Lyon, board member, and Karen, you can correct me if I'm wrong on all this, correct. The standards have increased, much like, Tempe has done a very nice job in terms of increasing their standards and their requirements along the way. The standards have changed. The one corner, because of the widening of baseline, some of their setback was taken away. Another corner, when it was developed, there was a 15-foot setback required. It doesn't look like there's quite 15 there, but that was a requirement at the time. Today is 20 feet. Again, we would meet it if it wasn't for a 65-foot dedication instead of 55. All the other corners have a 55-foot right-of-way dedication. City staff has requested that we give 65 so we can have the bus turnout lane. We are happy to give it, but for that, we need to reduce our landscape setback 8 feet.
And when we talk about, or you've talked about the 55 versus 65, that is a measurement from the center of the road?
Vice Chair, yes.
Board Member Pizakis.
I think I asked this question before. I'll ask of you. If for some reason the variance was not approved and you had to have a 20-foot, for some reason, that was it. Can it be designed into this facility?
Vice Chair, board member, we have an approved use permit right now to build a car wash on this lot. We would have to look at it. The best design of this automated car wash, we have already shortened it a bit, but in terms of the ultimate use and build out, this is the design we would like to go with because it's best for the customers, it's best for the city, and then we also, again, taking into account all the turning radiuses and the queuing and all of that. This is the best design that we have. If for some reason this variance was denied, we would go back and look at our design. We do have an approved use permit to have a car wash on the site. We'd have to go back and look at it.
Thank you.
Okay, other questions? Seeing none, I will thank our applicant. I'm apologizing that I went out of order a little bit.
Perfectly fine. Thank you very much, Vice Chair.
Okay. All right, so now we'll move on to our public hearing section. I have now 2 cards for people wishing to make comment. Again, if you would like to speak or have a comment read into the record, that can be done by way of these cards or at the back of the room. If you'll fill them out and give to our city staff, we can accommodate you. I have first Sylvia Aurelio, I think. Do you wish to speak?
Yes.
Okay, please. It is our custom that we grant 3 minutes.
Okay.
And do you run the lights here? We do at DRC. Do you do these lights here? Okay. So these little lights here in front of Board Member Frazee will let you know how you're doing on time. When you see yellow, you're running out of time. When you get to red, we'll ask you to please wrap it up.
Great.
If you'd state your place of residence and your name, please.
Yes. My name is Sylvia Orioli. I live at 1837 East Harbor Drive in Tempe, 600 feet away from where the car wash is going to be. What I'd like to do today is to add another dimension to this whole variance approval. Is like one of the things that I see missing is that there's a neighborhood that lives very close to this QUACK car wash that is being permitted at our corner. I live 600 feet from that location, as do some of my neighbors. And when I was here at the hearing officer meeting, Mr. Williams was very glad to see that there were several of us here and wanted to hear more from the neighbors. So what we did is we had an opposition, and we wrote letters to council, and we let our voices be heard that this is really not good for our neighborhood on Harbor Drive because we live so close, and also because this is just not a good fit for that property. Yes, they got their use permit, but please think about us. Not only are there many people in our neighborhood, but we did a change.org online petition to try and stop use permit. We had 82 people that are in support of not having a QUACK car wash on the corner of southeast corner McClintock and Baseline. So please, when you consider your decision, this is a very important decision for the neighbors. We are being very affected by this, by all of the changes in Tempe. From 3 lanes to 2 lanes has caused many problems. It's a public safety issue for us. We don't want this.
and want you to add that other little dimension that there are people, there's lots of people, and lots of people showed up for the DRC meeting last week when they were approved. I counted over 34 people that have oppositions with letters. Not all of them got up and spoke, but please consider us when you make your decision, because the neighbors would rather have something different to bring people together at this location. And I speak for many neighbors, and I can show all of you all of the numbers that we have, where the change.org location is. I believe I presented it to City Council, so please consider us in your final decision. Thank you for your consideration.
Thank you, Ms. Arioli. All right, I also have here a card for Jamie Burt, if that's correct. Again, if you'd state your name and your place of residence, please.
Hello, my name's Jamie Burt. I live at 8546 South Grandview Avenue, Tempe. I am also the owner of this property in question. And first of all, I just really needed to clarify for the record. I think it's item number 4, I'm sorry, I forget your name. Okay. That he brought up about, and this isn't the first time I saw some documentation earlier, that we as owners had known about this bus bay issue in 2014 when another applicant, you were dealing with another applicant to lease that property. And in fact, you know, I know it was an assumption because it's in the public record that since the city communicated to the applicant that a bus stop, or I don't know what the format was required or being asked for, that was never communicated to us. So we didn't know until actually March 6th of this year, when we just received a forwarded email from the city to QUACK, the developer, containing the comments for the first site plan submittal, I believe. That's when we learned of it, and we were very surprised and a little dismayed. So I just wanted to correct that, because that is continuing to be said, and that's not a fact. I'm trying to remember what else it was I was going to mention. Well, since I can't remember it, thank you for hearing me.
Thank you, Ms. Burt. All right, at this time, we'd like to ask our appellant to come to the podium again, if you'd like to address what you've heard.
Thank you, Chairman, members of the board. Appreciate it. I'll try to be brief and respond to some of the things that we heard. I'd like to reiterate, there's been talk of, well, the other parcels don't have the same right-of-way requirement. Well, actually, they do. When and if they come in to redevelop, that will apply to them. That is the rule of the game today. That is the city law. That's what applies to everybody. So the fact that the Caddy Corner property, for example, doesn't right now have an allocation for a bus bay, well, your city code says when they come in, if they're on the far side of an arterial to arterial intersection, they will have to dedicate that property. And then what's the scenario, right? Because now you've already established that this is somehow a special circumstance, when it's really not. It's just the code being applied as the code is applied. And then I'd ask you to look at what happens when they do dedicate this 10 feet. Well, they become a parcel that's 190 feet deep from the roadway. I've shown you a stack of parcels that are about that size or significantly smaller on arterial corners throughout the city. They become a parcel that's about 30,000 square feet. That's in line with many, many other parcels on similar street corners throughout the city and even just down the street. So even the application of this rule, if you thought it was being applied specially to them, which it's not, because it has to be applied to everybody because it's the law, it doesn't leave them in this unique scenario where they're all of a sudden, you know, too small to develop on, or triangular in shape, or does anything notable, special, or interesting to this parcel. It simply turns it into one with 190-foot depth instead of 200 feet. It's not special circumstances. And finally, I'd like to address, I think a good question was asked about, could you do this, if you had to accommodate the full setback and the full landscape. And I was actually frankly surprised by the answer, which is we would look at it. Well, test number 2 requires that a strict application of this code will deprive the owner of privileges enjoyed by other properties. They haven't made that case. If they're not even telling you that they can't even do this, they would just look at it. We don't even know if they're deprived of the right to do what they want to do anyway. So to wrap up, these landscape setbacks are not just for good looks, but they're also part of the adoption of them since 2010 has been a safety factor as well. They're between the sidewalk and driving lanes. There are going to be a lot of cars driving through this property. And that full setback, I haven't heard any reason why it shouldn't be maintained in this case. And there's nothing special about this property that rises to the level of requiring this variance to be issued in this case. So I appreciate your time this evening. Happy to answer any final questions.
Okay. Please.
Mr. Rose, right?
Mr. Rich, yes, thank you.
We had a lot of information before the meeting, and it's hard to digest everything that was handed to us just recently. One of the things that you had in your PowerPoint presentation was a quote from some recent case law. And I didn't see that in your letter, your original letter to the city that we've received that. Can you just go back? What was the point from that again?
So we can pull it up, or I can reread it to you, and then we can talk about it if you'd like.
I just want to, because I don't have it in front of me, can you just reiterate that?
Sure.
Again?
So with regard to test number 1 is when I raised that issue, and it's a case called Pond First versus Jakimek, Jachimek, which was decided this year by the Arizona Supreme Court. It said that you must show that the property's unique characteristics, my copies, that the property's unique characteristics create exceptional practical difficulties. And that's where I would ask you to look at what happens when they do dedicate these 10 feet. They just become a basically square property that's 190 feet deep from the road, about 30,000 square feet. It doesn't create an exceptional practical difficulty.
That didn't have to have a bus bay in it or anything like that, did it?
In that case?
Yes.
It was not about a bus bay, no.
Okay.
And in fact, in that case, the property was, because of condemnation that had occurred by the city that was unique to that property, it had shrunk the property down to about 12,000 square feet. And the court found that in that case, because it was so small, that the owner really didn't have a lot of options for what they could do. And as a result, they allowed them to get around some setbacks and other things because it was so much smaller than other properties in the area. I don't think we have that here.
Thank you very much. Thank you.
Okay, thank you, Boardman Confer. Any other questions, please? Okay, I think we're satisfied then. Thank you. All right. So now it's time for us to have a discussion amongst ourselves regarding the case. If anyone wishes to comment and describe their feelings or how they will be voting and why others of us might vote the same way. Please.
I do have some thoughts on this. The city has a code, and in this particular situation, I am going to adhere to that code for two or three different reasons. One is we've got the immediate property owner, Pollock Shopping Center, in opposition. We have the neighborhood in opposition, significantly in opposition. And then regarding the bus pullout, I have one pet peeve in the city of Tempe, and that is bus transportation that does not have pullouts and then impedes the smooth flow of transportation in the city. And that's just not, that's not at that particular corner, that's just my general upsetness.
Okay. Usually I like to wait, but I'd like to weigh in for a moment. So a couple of things there. Number one, I sit on the DRC as well, and I heard the QUACK case this past Tuesday, 8 days ago, not 1 day ago. And there were quite a few people who came and spoke on the case. I counted 45, and I may have missed a couple. And there were others who made comment, just read into the record but didn't speak. My numbers had 31 people said they were opposed and 14 said they were in favor. We heard a wide variety of opinions about what effect this might have on the neighborhood. And that's as good as far as it goes, but our purpose here tonight does not allow us to consider if people think the car wash on that site is a good idea. We are constrained only to decide if that variance was granted appropriately, regardless of what use is going on the site or how we feel about it or how others feel about it. So that's one note that I will make. I'm going to save the rest of my remarks until the rest of you had a chance to speak. Board Member Pizakis, please.
I've mentioned it a couple times. The thing that concerns me, or at least I guess bothers me maybe a bit, is whether or not the site can be redesigned to accommodate a 20-foot setback. It's a big site, at least according to the numbers, and you know, design professionals can do a lot of things. And all we're talking about, I don't mean to say that derogatorily, but there's 8 feet in question that would have to be accommodated. And I guess I just haven't got the right answer yet as to whether or not it could be redesigned to accommodate that. And that's the one thing that's nagging me a bit here. If it was absolutely no, it can't be redesigned, this is the way it is, and it's all said and done, well, that's one thing. I'm not sure I heard that. So I don't know if the rest of the board members heard that or not, but I didn't hear it tonight. So I just wanted to make that comment.
Okay. Board Member Collins.
My light's not turned. There it goes, green. My main concern is that whether or not we would set a precedence by saying that the new city code requirement of a pullout is a special circumstance. My concern is that then in the future, any place that is required, we've said that we believe it's a special circumstance. They don't have to apply by the code. That's my greatest concern here. I think the safety buffer, the landscape buffer is there for a safety reason. And I would be uncomfortable in setting a precedence that it's not that large of a safety concern on any of the corners that have a bus bay.
Fair enough. Other comment? Board Member Frazee.
Yeah, thank you. Yeah, I've looked at this from both sides, obviously, as well. And you know, one of the questions is this a special circumstance because of this bus bay? And is the bus bay specifically, was it designed or was it presented at a time during this application process? And I think when you look at this, as the staff's commented too, and as the attorneys have commented, this bus bay requirement is going to be there on this site, on new sites. That is part of the code. And I think that should be observed.
Okay. I have some thoughts, unless you want to weigh in first, Board Member Conford.
I don't have any comments right now, thank you.
Okay. Well, it's interesting to me because at our DRC meeting last week, We actually heard from a number of people that this particular site is too small for a car wash. People opposed to this project said that the minimum standard for car wash of this kind is a full acre, and this site is about 2/3 of an acre. And so we heard emphatically it's not enough room, and they're jam-packing this thing in there. So it's interesting to me to now hear this site is plenty bigger than you need to do a car wash. Well, I just think that's kind of an interesting note. It brings me back to the point that it's not up to me to decide how much space a business needs to operate. That's up to the people who want to start that business and to see if they can make this thing functional. It is my belief that the owners are going to attempt to maximize the site. If we tell them, sorry, you get to use only half of your site, then they will do their best to try and make money on that half of a site. So to me, it's not a matter of could something be done here that's different than what's being proposed. It's more a matter of does the applicant have some reasonable right to ask for this variance? I'll refer back to our opening statement here. Board of Adjustment is authorized, et cetera, et cetera. Its function is to grant relief where a literal enforcement of the zoning ordinance would result in an unnecessary property hardship. It's up to us to decide what that means and if that is the case here tonight. I believe that it is the case. I like landscape, I like trees, but in my view, the applicant did nothing to impose, to cause a bus bay to arrive there. It does restrict how much of their property is usable if we do the 20-foot landscape setback. There are, as we've heard, a number of properties in the area which have modified setbacks in the PCC1, and well, I guess I think that it is a special constraint. You know, I was thinking, supposing by some weird fluke I was informed that there's an easement that runs directly through the middle of the property my house is on, and I am now required to remove my house and build different. That would never happen, but suppose it did. I could conceivably find a way to make my house sit on one remaining side. But the fact that I can do it doesn't mean it's not a special problem. For my view, I believe that this is a special problem. So, if there are other comments, we'll hear them, and then we'll move on to a motion. Any other comments? Board Member Noggle?
Actually, I am ready for a motion.
Okay, other comments?
Vice Chair Lyons, I would have one question for you, is that based upon what you just said, then do you feel that any other location that requires a bus bay per code has a special circumstance then because part of their easement is more of their easement is being provided?
I wouldn't go so far as to make it a blanket statement, but I could see as how it would very frequently be the case. And I believe that it is our job not to sit here and figure out what the exact literal interpretation of the standards are, but to understand what their purpose is and if they're being applied correctly. We hear cases about people who's, want a different setback for their house and so on. And a literal interpretation doesn't give them any breathing room at all, but we grant variances. That variance is by definition when you are varying from the standard because there's some reasonable cause for that. So I would say that's our purpose, is to determine if this is an acceptable reason to make a variance.
All right, thank you.
If there are no other comments, I'll entertain a motion.
I'd like to make a motion.
All right, Board Member Noggle.
Yes, my motion is to approve the appeal of the October 3rd, 2017 hearing officer's decision to approve a variance to reduce the required landscape buffer from the street sidewalk for a maneuvering lane from 20 foot to 11 foot 8 inches for QUACK car wash located at 5201 South McClintock Drive.
Okay, motion to approve the appeal by, put forward by Board Member Noggle. Is there a second?
I second the motion.
Seconded by Board Member Collins. We'll put to a vote. All those in favor of approving the appeal by show of hands, please. Sorry, is there are there comments?
Can I ask a question, Mr. Chairman, before the vote?
Certainly.
I just want to make sure I understand the motion in a second.
Fair enough.
So the motion is to approve the appeal, which is denied the variance.
Can you say it again, Dave, for benefit of the microphone?
Yes. So, thank you. I tried to hit it. So the motion in a second is to approve the appeal, which would in effect deny the variance. Am I understanding that correctly?
That is my understanding. Is that correct?
I think I have before us the agenda item, which is the request, and my motion is to approve the request. And it's my understanding that that would then require that the property owner meets the city requirements.
Thank you very much.
Okay, so are we clear then? More questions, Board Member Kazakis?
The city's request, right now, the variance is for, to an 11-foot-8 setback, right? So that's what was approved.
Right.
All right, so by this motion, we are saying what?
If you raise your hand to vote yes, you will say they need a 20-foot landscape setback.
And we are then denying the.
We are technically approving the appeal to reverse the granting. So there are a lot of negatives in there, but okay, as long as we understand. All right, so we're ready to vote now. All right, all those who wish to vote to approve the motion to approve the appeal, by show of hands, please. Okay, and those opposed? All right, so that is 2 in favor, Board Member Collins and Board Member Noggle, with the rest of us opposed. That motion failing, we need to end on a positive vote. Do I hear a different motion? One possibility would be to put forth the opposite motion.
I'd like to make a motion to deny the appeal and accept the hearing officer's decision.
Okay, motion by Board Member Confort to deny the appeal. Do I hear a second? Okay, seconded by Board Member Pazakis, whose microphone is not cooperating. All right, so all those in favor of denying the appeal, by show of hands, please. And those opposed. All right, the motion passes 4-2 with Board Members Collins and Noggle in the dissent. All right, so that takes care of our agenda items, ladies and gentlemen. Do we have any announcements from city staff?
Yes, I'd like to indicate to the board and the audience that the terms of Chair Sell, Mr. Jan Sell, and Mr. Richard Kousel will end on the 31st, and I'd like to thank them for their service to the city. Thank you.
Mr. Abramson. So with that, we need to do a motion to adjourn. Motion, please.
Make a motion to adjourn?
Second, please.
Second.
All those in favor, show of hands, please. All right, we are adjourned, ladies and gentlemen. Thank you.